request that you kindly take your seat inside the auditorium, please. This is just a seating announcement. Distinguished guests, ladies and gentlemen, thank you for taking your seat. Today we will have the Indonesian National Dialogue on the UN Framework for Analysis of Risk Atrocities, a tool for prevention. This event is co-organized by CSIS and the Asia Pacific Center for the Responsibility to Protect. Today, in the morning session, we're going to have a keynote speech by Professor Fitid Muntaborn, Emeritus Professor from Chulalongkorn University, followed by a brief explanation on the UN Framework of Analysis for Atrocities by Dr. Noel Murada, Director, Asia Pacific Center for the Responsibility to Protect, and after the coffee break, we will have a discussion on how to contextualize the UN Framework for Analysis for Indonesia and the region. But before we proceed to the first presentation, we would like to invite Dr. Philip Permonte, CSIS Executive Director, to give a welcoming remark. Please, Dr. Philip Permonte, to come to stage.
Very good morning, distinguished guests. And first of all, I'd like to welcome you to CSIS to attend this event on the Indonesian National Dialogue on the UN Framework of Analysis for Risk Atrocities. And I'd like to thank Dr. Noel Murada of the Asia Pacific Center for the Responsibility to Protect in Australia, a long-time friend of CSIS. Noel is probably my long-lost brother. We born in the same maternity clinic in Manila. I didn't know that hospital actually exists until I met Noel. So I thought my father just made it up, and I was born in Vermont Maternity Clinic. So when I met Noel for the first time in 2002, he told me that I was born in that hospital too. So now I know probably we are brothers. And then this is not the first time we collaborate with Noel Center in Australia, and I hope that this will continue for many, many years to come. And also I'd like to thank Professor Fitid Muntaborn of Chulalongkorn University. We know your expertise. You are a very right person to speak about this here in Indonesia at a time of very relevant situation that I think not only us in Indonesia that face problems of extremism, potential for atrocities that actually still continue, regardless of the fact that we face so many new security challenges, but some old challenges remain. And then because of people like Noel and Professor Fitid and Ambassador Makarim as well, and Pak Reslan Jenny in the human rights mechanism, we are still able to think about and try to find ways in dealing with the challenge that we have. And of course, I'd like to thank as well speakers who spare your busy time to share with us here at CSIS. Professor Dr. Hafid Abbas of the Indonesian National Commission on Human Rights. He was the commissioner 2014-2015. Thank you for coming and agreed to speak on this event. Ambassador, I see Pak Ambassador Reslan Jenny, of course, with the IPER, that will play a very crucial role to come in this area as well. And former I-Chair, Pak Effendi Jamin of Human Rights Working Group. Thank you for agreeing to come, and other speaker, and you, of course, participants to the discussion. So I do hope that because the focus will be on Indonesia in the session after the coffee break, please feel free to discuss, because I think this is the right time for us to openly discuss our challenge of the rise of extremism, intolerance, because as we all know, it is complicated by the fact that we are also facing election. So there is the human rights phase of this, but also there's the political phase of all these issues that we are going to discuss. And without having a frank discussion, I think it will be very difficult for us to find sound, what it calls here, prevention to possible and deeper conflict in the years to come. Once again, I'd like to thank you all for coming. I wish we have a very good discussion in some hours ahead. Thank you.
Thank you, Dr. Philip Formonte, for your welcoming remark. Next, we will also invite Dr. Noel Morada, Director from the Asia Pacific Center for the Responsibility to Protect, to give his welcoming remarks. Please come to stage.
Thank you very much. A very pleasant good morning to everybody. I'm representing the Asia Pacific Center for R2P in the University of Queensland.
Okay, yeah, that's better. I'd like, of course, thank Philip Vermonte for hosting on behalf of the CSIS this dialogue that we're having in Jakarta. I just came in actually from Bangkok, where we had a series of meetings with our partners in the region on atrocities prevention. And I'd like to really acknowledge the continuing support of CSIS and other partners in Jakarta regarding our Indonesia program. Of course, I'd like to also acknowledge Pak Makarim Wibisono, who's here, who's a member of the high-level advisory panel that produced the mainstreaming of responsibility to protect in Southeast Asia, which is a continuing project of our center in the region. Ambassador Jenny, of course, thank you for coming in today. Ambassador Jenny is our engaging work with the AIPR, hopefully in the long term. And Professor Abbas, whom I met in Uganda last May with GAMA. And of course, Rafendi joining us here, is a continuing supporter of our program. And of course, Professor Vitit, who accepted our invitation to deliver the keynote for this morning. Our interest also in promoting the responsibility to protect and atrocities prevention is that there are a lot of continuing issues in the region where we think that Indonesia can actually play an important role, and we hope that many of our programs in the region will continue to get the support and increase public awareness about mainstreaming responsibility to protect. So on behalf again of the Asia Pacific Center for R2P, I'd like to thank you all for coming today. And of course, my thanks to Lina for coordinating the preparations for this activity for today. Thank you very much.
Thank you for your welcoming speech, Dr. Noel Morada. Now let us proceed to the keynote speech by Professor Fete Muntaborn, Emeritus Professor from Chulalongkorn University, that will be moderated by Dr. Philip Vermonte, the Executive Director of CSIS. First, I would read the short bio of Professor Muntaborn. Professor Fittit Mutaborn was educated in the United Kingdom, obtaining his undergraduate and graduate law degrees from Oxford University. He also holds a degree on European law from Free University Brussels. He is currently professor of law at the Chulalongkorn University in Bangkok, teaching international law, human rights, the law of regional organization, migration and refugee law, child right, international humanitarian law, and European Union law. Professor Mutaborn has served on many United Nations bodies. I speak to him yesterday and he already conduct research for the United Nations since 1990s or even before. He holds previously the United Nations Special Rapporteur on the situation of human rights in the Democratic People's Republic of Korea. He also has been Special Rapporteur of the UN Commission on Human Rights on the sale of children, child prostitution, and child pornography. He has additionally participated in many international fora in the rights of the child. Professor Mutaborn has performed a substantial amount of work with non-governmental organizations in the field of human rights as well as with the Red Cross and Red Crescent. He is also well published in human rights issues, including women, children, and human rights and human development field. Therefore, we would like to invite Professor Fittit Mutaborn and Dr. Philip Ormonte to come to the front.
Good morning. Selamat pagi. It's nice to be in Indonesia again. Thank you very much for the invitation to be here. It's tremendous always to be here. I was here last year. I'm going to be here in 3 weeks, so I can feel it's sort of first and second home together. And thank you, CSIS, for being a friend for so long, Clara, Yusuf, and others. I was here in the 1980s doing research for 2 books. So I'm very grateful to CSIS for that in terms of hospitality. And thank you, the Asia Pacific Center for R2P, Noel, and friends for the kind invitation. It's an honor and a pleasure to be here. I come as a friend of the region, and I'm very proud of Indonesia as one of the democratic countries of this region. And as I was joking earlier, in 100 days, ASEAN has witnessed 2 to become 3 in terms of multi-party democratic system. Now 3 countries which are multi-partite, happily, and of course Indonesia is one of those. Let me start briefly by uttering 2 comments, and I want you to test yourselves on this. Someone says, I hate them. I hate them. Should we make that illegal or not? Or is there another way of dealing with it? Someone's expressing oneself, not nicely. But maybe if that sort of comment is made, we have to think around how to respond. Maybe through a broad education process. If it's on social media, maybe counter speech to say we disagree. And so on. So that's one comment. Second one. I hate them and they should not live because they're maggots, cockroaches. That sounds much stronger. It's inciting something nasty to be done to someone else. And in international setting, international law and human rights law, that is a comment which should be prohibited, because it is inciting attack on a group or someone, even though the attack might not take place. So you can see the delicate balance between I hate them or we hate them, and we hate them and they don't deserve to live. And so we have to look to some guidance internationally to see where the balancing act comes into play. Because if we leave it to national sentiment alone, all passions come together and there's an explosion without much reasoning at times. So we look into reasoning in terms of rights and configurations in terms of limits, if those rights can be limited. So that's what this morning's about, between those two comments and where we go with democracies in this region. Freedom of expression as a right opens the door to many other rights. Freedom of association, freedom of peaceful assembly here to speak is very much linked with freedom of expression. And non-democracies have a problem with freedom of expression because they don't like freedom of expression too much, because freedom of expression is about democracy, inclusion, participation. While democracies also have an issue with freedom of expression when they seek to invoke national security or when they seek to invoke limitations, particularly to address those two comments that you just heard. And those two comments demand a variety of responses, not just law against, but a variety of responses. And there is no substitute at all for an informed and educated public. That's what freedom of expression depends on. Informed, educated public. To make up our minds ourselves, to critique with reason, and to move on. When we look at the term atrocities, there are three main misdeeds we look to. Genocide, that's attacking with a special intent group. And just 2 days ago, the Keynote Commission came out with a finding that genocide has taken place in Rakhine, particularly in Myanmar, concerning the Rohingya. Crimes against humanity, which are crimes based upon widespread and systematic attack upon the civilian population. And war crimes, crimes in time of war, civil war or international. And we have another word, ethnic cleansing, which is about forcible displacement. But that's not quite a substantive crime in international criminal terms, even though it is invoked as a sort of description of a crime internationally under R2P. And as you will hear later, we have two UN frameworks to deal with these situations, to deal with, from the angle of R2P, the UN framework on analysis for atrocity crimes, and the framework concerning religious leaders, which is a very good framework that I invite you to bear in mind, which I will refer to on and off. The first thing to realize is that although freedom of expression is a right, it is not an absolute right. Freedom of opinion in my head is absolute, but when I say something out, it is not absolute. It can be constrained. And the issue is, what are the possible limitations for freedom of expression? And what are the criteria? What are the criteria for the limitations? The limitations of the limitations. And that's what we're going to look at in a moment. Limitations are possible for freedom of expression, particularly under the Universal Declaration of Human Rights, which establishes impliedly there are standards, such as if you're going to limit rights, such as freedom of expression, you must do it by law, not by fiat, not by just a feeling from a coup d'etat or whatever. And it should be reasonable according to what democratic countries do, proportional to the circumstances, and so on. The main guidance to deal with those two situations that I referred to earlier, I hate them, shouldn't be illegal necessarily, but there are other ways of dealing with that. I hate them and they don't deserve to live because they're maggots, cockroaches. That should be illegal, prohibited. The guidance to deal with those situations come particularly from the Covenant on Civil and Political Rights, to which my country and Indonesia are parties, particularly Articles 19 and 20. These are the two articles that provide us with a guidance on the balancing act. Provision 2, everyone has the right to freedom of expression. And that means seeking, receiving, and imparting information. It's a two-way flow. Not just to say something, it's also to seek and to impart, orally or otherwise. And that right to freedom of expression is not absolute, as listed in Provision 3, sub-article 3. There are two main exceptions, limitations possible. Number one, we can limit freedom of expression if we are trying to protect the rights and reputations of other people. In other words, defamation. You can't call people by nasty names. That is considered to be defamation, defaming someone, affecting the rights and reputations of others. That's one possible limitation on freedom of expression. The second one is to invoke national security or public order or public health and morals. So national security can be used to constrain freedom of expression, but it must be tested according to international standards. So we will look to limits on the limits in a moment in terms of criteria. And Article 19 is expanded in terms of hate speech by Article 20, particularly Proviso 2 or Sub-Article 2 guides us on whether we should have a law against hate speech or not. We need a law against hate speech if hate speech falls under this proviso: advocacy of national, racial, or religious hatred that constitute incitement to discrimination, hostility, or violence shall be prohibited by law, criminal law and or civil law. That covers comment number 2, not comment number 1. It is not generally illegal to hate someone, not by law, but we have to tackle that through education, open-mindedness, understanding, cross-cultural, intra-religious understanding. But it must be illegal by law if it is advocacy of national, racial, or religious hatred. That's tantamount to inviting discrimination, hostility, or violence. And that is expanded by the Convention Against Racial Discrimination. It should be prohibited, it should be forbidden if wording is used to stipulate racial superiority and if it incites racial hatred. I hate them because they are racially inferior. That is a situation which should be prohibited by law, whereas I hate them might not have to be covered by law, but by other actions in terms of broad-mindedness, counter-speech, education. And we are also invited by the Convention Against Genocide to act against incitement to genocide, which is attacks against specific population based on intent. Well, what are the limits of the limits when we say freedom of expression can be limited by defamation, rights and reputations of others, and national security? But what are the limits on the limits? Usually, the criteria for limiting freedom of expression and other rights are as follows. The state that's trying to limit freedom of expression must prove that it's limiting expression based upon the law, compliant with international standards. So that is the principle of legality. You can't have an arbitrary, discretionary act. Secondly, the limitation must be necessary according to dangers, what the national security people would look at in terms of risks and dangers. Thirdly, the state has to prove proportionality. One little threat and a certain state closes all media. Ridiculous, cannot. Not proportional to the circumstances. And under the Covenant on Civil and Political Rights, the Human Rights Committee that monitors implementation of the covenant, has also said that we must comply with the non-discrimination principle and universality of standards. Bearing in mind local wisdom, but universal standards, UN and so on. And last but not least, we test according to what democratic countries do generally as well. We can call that legitimacy. In tangible terms, these are the entry points for limits on free expression. And many of them are interlinked with atrocities in one way or another. Defamation, affecting rights and reputations of others. Privacy, national security, child pornography, incitement to genocide, incitement to hatred and violence, and incitement to terrorism. Let's look at them briefly. Defamation is about harming people's reputation. You can limit freedom of expression on that basis. If it's defamation in written terms, it's also known as libel. If it's defamation in spoken terms, with a certain witness, it's known as slander. And in many of our countries, defamation is not only a crime, but also a civil tort. It's a wrongdoing in civil liability. But the international trend is to advocate that defamation should not be a crime, but should give rise to civil liability. That is the international trend. But in ASEAN, it's also a crime in many countries, including my country. Privacy. Everybody has a right to privacy in terms of our personal identity. And particularly children should be prevented from attacks. Public figures have to be slightly more open in terms of attacks. Their privacy can be infringed more easily, I suppose, because they're public figures. And very interestingly today, all of you appear on internet, particularly Google. Your privacy is affected. Can you have the URL on Google taken down if you feel impinged or infringed? The answer is yes. You can ask for the information to be taken down from the internet, and this is now known as the emerging right to be forgotten. We have a right to be forgotten that interfaces with freedom of expression, particularly on the internet. National security, be careful, because the IR people will tell us that security is based upon threats, and threats are based upon a threefold possibility. One, actual threats. Two, potential threats. Three, fictitious threats. What are fictitious threats? Fake threats. Fake threats, which are used to constrain free expression. So be very careful with fake threats when we invoke national security. And then we have all these laws that come into play in terms of Security Act, lèse majesté, sedition, martial law, emergency decree, treason. They need to be tested through the eyes of those standards that I referred to earlier, like legality, proportionality, necessity, non-discrimination, universal standards, and legitimacy. If they pass the test, fine. If they don't pass the test, they need to be questioned because they're not compliant with international standards. Child pornography. In some countries, some lobbies claim that if we limit expression because of child pornography, it is a breach of freedom of expression. It is not. You can limit expression if it impinges upon child rights, particularly child pornography. You can limit freedom of expression. But adult pornography is unsettled. Over here it's illegal, in Thailand it's illegal, in Europe it's not illegal. Not everything is settled in human rights, happily. So you have to debate, but over here adult pornography is legal, like in my country, I presume. Incitement to genocide. Many cases, particularly on Rwanda, that you know about. And genocide is guided by the Genocide Convention. Act with intent to destroy. Let's look at this case study briefly. I hate them. Should that be illegal by law? Is it incitement to violence? The answer is generally not, because people hate people, sadly, but you have to counter it through other means. X says about Y as a group, they are collectively maggots who don't deserve to live. There should be a law against that, and the law would be combined with Articles 19 and 20 of the Covenant on Civil Rights, as well as the Racial Discrimination Convention, as well as the Anti-Genocide Convention. So, the latter would be incitement to genocide, which should be prohibited. Incitement to hatred and violence. Remembering that it's not illegal to hate, or should not be illegal to hate, but if it is incitement to hatred which leads to violence, or discrimination, or hostility, that should be prohibited. In other words, the area of prohibition should be one where you are provoking someone to be nasty to someone else. It's a triangle. I provoke you to be nasty to someone. 1, 2, 3. It's a triangle which should be prohibited. Not just incitement against an idea. It must be to do with human beings in terms of incitement. And you have it in your law. Indonesia Penal Code. The person who publicly gives expression to feelings of hostility, hatred against a group shall be punished. It's a triangular relationship that's already prohibited in Indonesian law. In fact, Indonesia, you have many laws already. Maybe you don't even need some of them. Think around it. You don't need more law necessarily. Very often there are too many laws in developing countries, and we'll see how and why. And those laws actually might lead to some sort of incitement to hatred rather than the reverse. Don't over-legislate, but build educated, informed people who can think for themselves. That is much more important. In Australia, the incitement law is at the federal level and at the state level. At the federal level, it is civil liability. At the state level, it can be criminal liability. So it has both. And in New Zealand, it is civil, but it can be converted into criminal liability responsibility if you have the Attorney General agreeing. So it's a mixed bag. Case study. A bullies B. Push. Is that a way for us to have a law against? I don't think so. There are other ways. Empathy, understanding, not to bully. A whispers to C to bully B. That's almost a triangle, but it's a whisper. You have to look at the context as well, you know. If it's a war situation, I'm a big prime minister saying, bully B, meaning that group, you know, that might be incitement to hatred that should be prohibited. A makes a public statement calling on the community to bully B. That is definitely one that is provocative, and it's incitement to hatred that should be prohibited. So you can see the nuances in terms of differentiation between statements that have impact. And today we have criteria, again, on when something becomes incitement to hatred that should be prohibited. We have the UN-backed Global Plan of Action of 2012 in Rabat concerning hate speech. You have to look at their situations. The context, the speaker, plus context. A statement in war is going to be much more inflamed than a whisper between me and our chair there. So, the war situation should lead to prohibition of that speech. Speaker, the big prime minister who makes it outward, is going to have much more impact than my humble self, and that's a situation inviting prohibition if it's a big impact on the population. Intent. It should be prohibited if there's intent. Negligence is not enough. Content and form, if it's provocative. Extent of the speech, whether it's a private whisper or public voice. A whisper on a phone is not something you're going to prohibit. but a public manifestation is one invites response, and likelihood and imminence of risk and danger might ask us to have a prohibition vis-à-vis that hate speech. Not all hate speech should be or can be prohibited. I hate them should not be prohibited. But hate speech, which is tantamount to incitement to violence or hatred, should be prohibited. That is the difference. And you have it in Indonesian law, but maybe you need to look at other laws which are not necessarily reflecting international standards. Blasphemy. The Covenant on Civil Rights has a Human Rights Committee that has guided us on blasphemy laws. General Comment 34 from the Human Rights Committee advises that laws prohibiting blasphemy are not in conformity with the Covenant on Civil Rights. Critique of religion in international law is possible, and we need to counter that maybe through counter-speech, analysis, discussion, rather than a criminal law, and certainly not a criminal law that leads to execution, punishment, and corporal sanctions. So, in the UN, we've had to deal with the notion of defamation of religion, and what we try to do is to nurture a sense of understanding without using a criminal law when there is a critique of a certain religion. And in any case, defamation is about effect on reputations of human beings rather than impact upon a belief. So we overcome this by coming to the Rabat plan of action to look at other ways through education, counter-speech, to deal with this situation rather than a prohibition under criminal law. Incitement to terrorism should also be prohibited, but the problem with this is that the notion of terrorism is not clearly defined. But in Europe, the European Union has a law which invites countries to have a law against terrorism, and we have vague laws in Europe which also need to be questioned, such as the prohibition of glorification of certain ideologies. And today, finally, we have the SDGs, which governments like as an entry point to peace and development. And particularly the goal 16 is one that's interlinked very much with freedoms, peace, human rights. So SDG 16, calling for an inclusive society, invites us to take a balanced approach to free expression, invoking democracy and its link with peace and sustainable development. Finally, what possible actions for the future in terms of possibilities in our midst? The entry point for human rights implementation offers a variety of possibilities. One, good laws. You need a law against incitement to hatred. Situation number 2, that I referred to earlier, compliant with Article 20 of the Covenant on Civil Rights. But you don't need a law against hate speech as a whole. You can't. Doesn't work anyway. There are other ways to operationalize. And you need to reform not so good laws, particularly on censorship. And pending that, don't apply bad laws. We call that moratorium. Many countries have bad laws which should not be applied. 2, policies. National policy on human rights self-regulation by the internet industry can help in terms of action against incitement to hatred. Programs including technological responses. We have filters that we can use today through technology to filter against incitement to hatred. Compliance with court decisions and so on, international standards. One difficult and interesting area is this. We have international guidance on denial of Holocaust. Some countries, about 20 countries, prohibit denial of Jewish Holocaust. This has been found to be legal in international law. But recently, one country tried to prohibit mention of Armenian genocide, and the European Court of Human Rights said it's not illegal to prohibit mention of Armenian genocide. So there's variation there in terms of proof, I suppose, or what international standards accept as proven facts. So there's variability there too. But I'm not saying you must have a law against denial of the Holocaust, but I'm just saying that about 20 countries have these laws and they're found to be compatible with freedom of expression internationally. Mechanisms and personnel, Human Rights Commission, Komnas HAM, Komnas Perempuan, working with technology industry to help prevent hate speech, religious groups, intra-faith, interfaith, very important to help prevent incitement to hatred, particularly on religious grounds. Resources, not just money, but more, social capital, volunteers who can help, and don't fund those agencies that incite hatred. Very important. And we have external funders funding several groups. We have external funders funding ISIS in Syria, for example, to utter hate speech against many, including Yazidis, in terms of genocide. We need information and monitoring of situations, and famously now, the two-day-old report on Rakhine has a lot about hate speech. Let me cite, finally, some words for you on Rakhine. The mission is deeply disturbed by prevalence of hate speech, offline and online, often including advocacy of national, racial, or religious hatred, constituting incitement to discrimination, hostility, or violence. This has accompanied attacks of us in Rakhine State. Dehumanizing and stigmatizing language against the Rohingya and Muslims in general has for years been a key component of the campaign to, quote, protect race and religion, unquote. So be very careful with campaigns, quote, to protect race and religion, because in fact they do the reverse. They lead to crimes ultimately, as in Rakhine. Finally, education, capacity development, no substitute for a liberal mind, avoid violence, use counter-speech rather than censorship. With regard to accountability, in human rights terms and remedies, prevention also means non-recurrence, as well as compensation and beyond. And last but not least, networking, mobilization, participation with great leadership required. Interfaith dialogue, inter-community, youth programs, cross-cultural understanding is best. So prevention ultimately is better than cure, and let's look to a delicate balance, inviting sense and sensibility in our shared responsibility. Terima kasih.
Thank you very much, Professor Muntabon, for your very enlightening and insightful keynote speech that I think hit our mind, especially when we put it in the Indonesian context, because many of what you mentioned in the speech actually are exactly the problem that we are facing right now, and probably you change some of our understanding or you reinforce some of our understanding. Now, if I may, we still have about 15 to 20 minutes for Q&A. Before that, if I may use my authority as a chair, because you strike some fact that number one, it seems to me that all this goes down to some subjective understanding, and then that's also that creates the problem when it comes to how do we put the limits on the limits. For example, I couldn't imagine our lawmakers in Indonesia could agree upon on this limits on the limits, because that's exactly the problem. Because they don't want to limit the limits, and then how in the experience of some other countries in dealing with this kind of a subjective assessment of the situation. Probably you may give us some enlightenment. Number two, you mentioned in your last part of the presentation about the denial of the Holocaust and all that. And that's also, I think, the problem with the international law, because some people might say different standards are applied, and this is, I think, something is very difficult to deal with. Stephen Krasner, the professor of international law, I think one time in his book mentioned this is about organized hypocrisy when it comes to international law, sovereignty, and then how we apply international law. And in your opinion, how do we deal with this kind of also the perceived different standards applied in many cases? That's my two questions. You may or may not deal with now, because I'd like to open the floor for the participants to raise their opinion, or if they have questions to Professor Fitid. Now I'd like to welcome you all. Please come to the microphone, identify yourself. Number one, the lady over there, and then if there's other who would like to ask a question, we can start with the lady, please.
Good morning. My name is Nadia. I'm from Stara Institute, an NGO work for democracy and peace. I have a question regarding the rights to privacy that you mentioned earlier. But before, I'd like to, elaborate with the context in Indonesia. Right now, there's a trend where civil servant may or possibly affiliate with radical groups, or we call it terrorist group. For instance, there's a wife of terrorist in Sidoarjo that is actually a staff of the Ministry of Religious Affairs. And second, there's a news that some civil servants in state-owned enterprises have funding for terror activity in East Java. And also there's a civil servant in the state higher education institution in Banyuwangi that is indicated as member of a terrorist group, or not as far as directly involved in any terrorist activity, but simply it shows that intolerance starts to spreading among the civil servant or government institutions, and mostly it's religious intolerance. And my question is, in order to prevent and combat what's so-called radicalization within the internal government institutions, there are inspectorate generals who are assigned to do background check for every member of their institutions to make sure that they're clean and clear. But to what extent such prevention strategy can be applied without violating their rights to privacy? Thank you.
Another one, or we can just invite Professor Fitid to respond to the question.
Thank you, Chair. Subjective, objective. What sort of test do we use for freedom of expression? If you leave freedom of expression to the local setting, even with a lot of local wisdom, often it is a subjective response, particularly it's to do with limits. National security. We have many situations where national security is based upon fake threats, particularly those countries where the military come in and stage coup d'etat, which shall remain nameless. So we have to be very careful. And even though the UN system, the global system is not perfect, you have international committee standards that guide us objectively. And Human Rights Committee under the Covenant on Civil Rights has already guided us with an interpretation that provides objective assessment in terms of those criteria that I referred to, limits on the limits, legality, necessity, proportionality, universality, non-discrimination, and legitimacy. And we're all engaged. Indonesia, Thailand, all part of the Covenant. We go to universal periodic review. We engage with special procedures. You have a certain catalyzation process already, which is not totally objective or subjective, but it's mutual empathy that comes through a dialogue process. And certain things are dependent upon a step-by-step approach. And I said already, we have a lot of good laws and bad laws. The bad law you're not going to reform overnight, but you don't have to apply them necessarily. So it's a step-by-step affair. Secondly, leadership is very important on that. What the leader guides publicly is very important as exemplars of what the community should orientate towards. So I don't want to deny the role of empathetic, liberal-minded leadership there. On all sides, political leadership, cultural leadership, religious leadership, social leadership, community leadership, youth leadership. With regard to the second question from our chair on international standards being, well, maybe double-edged, double-standard-based, Holocaust denial, illegal in some countries, not, and so on. There are many issues on which we can agree. And there are some issues with which we are not in agreement, but let's go for the ones that we agree upon first. And we already agreed upon Articles 19 and 20 of the Covenant on Civil Political Rights in terms of the need to prohibit incitement to hatred. We already agreed on anti-racial discrimination under Article 4 of the Convention Against Racial Discrimination. We already agreed upon action against genocide-related incitement under the Genocide Convention, to which some of our countries are parties. So those are not Western or Eastern at all, but we agree that we must take action. And international standards are not about basic maximum. They're about basic minimum. Don't go below the basic minimum. If we have the wisdom in the region to elevate those standards beyond the basic minimum, great. Prove it. Of course we can prove it. Ahimsa, non-violence, Gandhi, wisdom from localities, environmental protection from the indigenous peoples, and so on. All those help to raise international standards. So it's understanding that international human rights law is about basic minimum. If the locality wants to do better and more, clap, clap, applause. So there's no inconsistency there, on which we can agree on many fronts. And sovereignty is a very important concept. It's in the ASEAN Charter, it's in our constitutions, but sovereignty has never been absolute. Sovereignty doesn't mean you can kill people just like that in terms of genocide. Isn't that what the Khmer's were doing? Isn't that what some groups have been doing in regard to Rakhine? Internationally, also we've tried to understand sovereignty from a different angle. The Rakhine report talks about responsibility to protect, including from the leader. Including from the leader, not just from the army. So it's interesting that sovereignty is now understood to be more people-based, especially if you look at SDG 16, which is about inclusion. Sovereignty has to be an inclusive, people-based exercise. And freedom of expression is not Western, it's in the ASEAN Human Rights Declaration. It's in all our constitutions. So if you look at sovereignty in that perspective, it's very much ASEAN-oriented as well. Give or take in terms of expression, but of course the limits of limits have to be understood objectively, not nationalistically, but subjectively, if they lower basic minimum. And finally, on privacy, I would just say that very importantly, it's incumbent upon us to promote more interfaith dialogue, intra-faith dialogue, also between civil servants and beyond. You know, one of the recommendations from the UN's Plan of Action for religious personnel is to ensure that military officials and potentially civil servants are all educated on different religions so that they understand what it means to be Buddhist, Muslim, atheist, or beyond. My students many of them have never been to Southern Ireland. Southern Ireland is Muslim populated. I go to Southern Ireland. But many of my students have never been to Southern Ireland. So circulate them Likewise, civil servants and beyond. You can't do this by prohibition, by law alone. We want an informed, educated, open-minded, inclusive public for which there can be no substitute.
Yes, please.
Hi, Hiro from the Jakarta Post. Can you comment on some individual blasphemy cases in Indonesia? For example, the jailing of Ahok, the former Jakarta governor, and more recent case, I think this happened last week, in which this middle-aged non-Muslim woman found guilty for complaining about the speaker. Thank you.
Anyone else? Oh, I can still have time. All right. Yes, please.
Good morning, sir. My name is Fada from the Jakarta Post. Based on what I've read from framework analysis of atrocity crimes by the UN, especially there are several risk factors and specified risk factor too. Report of serious violations of human resource and humanitarian law. There is a high significance and high tendency of a country that had experience in atrocity to have experience of atrocity in the next future. And my question is there a high affiliation between the law of the process, which is based on the experience that the country had with the current situation of protection for the law? Thank you.
With local situations, either in this country or elsewhere, very good documentation from the Human Rights Commission, generally. So many of the cases that you refer to are already dealt with, or could be dealt with by either Commerce Ham or Commerce Perempuan. So I would refer you to those, including the issue of plurality of religions and interpretations, for example, which has been dealt with by Commerce Ham, for example. With regard to application of laws, I've already said that you have to take stock of whether laws are compliant with international standards, because your country, my country, are all parties to international treaties on this, particularly the Covenant on Civil Rights. So I would urge you particularly to balance between local interpretations of limits on freedom of expression and international, more objectivized tests that have been referred to by me. Secondly, on serious violations of humanitarian law and so on, I think one of the interesting propositions of the UN Plan of Action on prevention of atrocities, including the reference to religious leaders, is to be able to teach about atrocities. So you get back to the educational process of how pluralistic are we in terms of how we teach history. And not many countries are pluralistic. I mean, I was taught history in Europe, and it was all about, European victories. Well, I mean, Columbus went off to the Americas, and look what happened to the indigenous peoples. I wasn't taught about that. So I think it's very important to teach alternative histories, alternative narratives, counter-narratives, to enable people, particularly from a young age, to understand varieties and to have a certain interpretation. And this applies to religion. Different interpretations of religion, also very important. Every religion has differences of interpretation, and we have to be open-minded about the possibility of plural narratives, not monolithic versions. I give you two examples, very, very interesting example. Just next door, we have the Khmer Rouge Tribunal. Khmer Rouge Tribunal in Cambodia, genocide, crime against humanity. You know, we complain that, oh, they've only decided on 3 cases, spent $100 million and so on. But don't forget, the trials have been witnessed by over 200,000 people sitting there watching as an educational process. A lot of people don't know that. So imagine those 200,000 people witnessing these trials, learning and sharing with the community the impact. It's very important to have examples which catalyze the mindset. So a good judicial process is not just going for compensation or sanction against someone. A good judicial process has to be a learning process for the community in terms of ethics and standards to help prevent the possibility of reversion to those sad occurrences of violations. So likewise, all these UN reports and so on, including the new Rakim report, you know, these are very good history books. They document information and they have to be taught. So back to square one. Who writes history in your country? How pluralistic is your country in terms of history? And how is it taught? We must aspire towards more inclusive history as well as inclusive participatory education.
Thank you, Professor. I think we've reached the end of this session. If there is one more that can, okay, I'll give you the microphone. Please deliver.
Yes, yeah. Hello, I'm Kathy from Paramadina. I actually want to follow up on the blasphemy cases because if we see at the case right now, there are 2 recent cases about Ahok and also the middle-aged women. Both come from minority groups, and we know that actually there's like political motivation behind it. But if we look at the limitation of freedom of expression, people, the 2 cases actually being accused for blasphemy law, but we know that they both are coming from minority groups. So I actually want to ask how, and the fact that they're actually disturb the public order, like people are getting uproar about that. How the international law actually look at this problem, and it is justifiable for the court to say that this is actually some limits of freedom of expression that they have to address. I think that's my question. Thank you.
We have a general principle in rule of law practices, judicial deliberation and so on. If a court is listening to witnesses before decision, before judgment, that is considered to be in law globally known as sub judice, pending judgment. So you can't cite everything in the media at that point in time before the judgment comes into play. Okay? I mean, I was witnessing a trial 2 weeks ago. I'll give you an example, live example. Yeah? On tourism. And NGOs wanted to publish testimonies of what was being heard in court at that time, before the court went to judgment. And I, as a friend of NGO, said, hey, wait, this is known as sub judice, pending judgment. You can't comment yet. Okay, wait until a judgment comes and then you comment. So that may be helpful in terms of understanding of the global principle of respect for the court. Otherwise, you have another limit of free expression, which is sometimes abused, but sometimes correct, contempt of court. So be careful also when you comment on court cases before the court has adjudged. There might be contempt of court. And in some countries, contempt of court is overused. So be careful with contempt of court. They must be in accordance with international standards. And last but not least, checks and balances is very important. You work in human rights, you work on RTP, you're dealing with power, not just principles and standards and norms. How do you deal with power, particularly abuse of power? You try your best to establish checks and balances. At the local level, executive, parliament, judiciary, Strong civil society, strong media, strong social media, very important. If it doesn't work there, go regional. Claim at the regional level, maybe. Your foreign minister, your ASEAN, maybe. You have an ASEAN charter, maybe. If it doesn't work, go international. You have UN human rights system. All ASEAN countries are parties to 3 human rights treaties. CEDAW, Women's Convention, Child Rights Convention, CRC, and CRPD on disabilities. But many ASEAN countries, about 6 or 7 now, including Indonesia and Thailand, are parties to the Civil Political Rights Covenant, which touch upon these very sensitive political rights, which are at the heart of democracy, particularly freedom of expression. We have also special procedures, UN Special Rapporteur on freedom of expression. You can complain to them if there are violations without the need to exhaust the local remedies. I was UN Special Rapporteur on Tailored Children or North Korea. All the time. All the time. And we would interact with the state to ask for justice and litigation. You have UPR, Universal Periodic Review, which also motivates gentle change at the local level. Many of these issues are there already, advised through the UPR. So make use of all available checks and balances. And please never feel frustrated on human rights. We will give hope and will be examples of giving hope. Thank you.
Thank you. Time is our limit, and I believe everybody in the room agrees that this has been very inspiring and insightful discussion with Professor Fitid Muntabon. We still have a coffee break. If you want to follow up directly with Professor, please do so. But now, please join me in thanking Professor Fitid Muntabon for very enlightening session.
Thank you for an excellent keynote speech and discussion, Professor Fitid Muntabon and Dr. Philip Vermonte. Distinguished guests, ladies and gentlemen, now we will have a short coffee break outside the auditorium, and we will come